Good afternoon, ladies and gentlemen, and welcome to the first of the 2014 Hamlyn Lectures, which are a progression which will move from Oxford to Queen's University, Belfast, and then to London, and on into the operations of our beloved friends, Cambridge University Press, who will produce the lectures as a volume that will become part of a heritage in legal studies in this country that's of interest not only in this country, but as part of legal studies around the world. So I'm delighted that the Hamlyn Lectures are starting this year in Oxford, and I'm delighted that two of the trustees, Professor Avram Sher and Sir Stephen Sedley, are with us. The Hamlyn Lectures are so important that we need someone to introduce the introducer, and it's my privilege to call on our colleague, visiting professor in the Faculty of Law at the University of Oxford, Sir Stephen Sedley, to introduce this year's lecturer. He ought to know how he himself gave the Hamlyn Lecture in 1998, as well as being a trustee of the Hamlyn Trust. Sir Stephen Sedley.
Well, thank you very much, Timothy. Welcome all of you to the 66th series of the Hamlyn Lectures. It's my privilege on behalf of the Hamlyn Trust to introduce this evening's lecture. When Emma Warburton Hamlyn died in 1941, she left the estate that she'd inherited from her father, who was a well-known Torquay solicitor and JP, for purposes which were initially considered to be too uncertain to be given effect. Having loyally discharged every testator's first duty of providing work for the legal profession, her will trust was finally approved in 1948 by the Chancery Division for the following purposes. I quote, "The object of the charity is the furtherance by lectures or otherwise among the common people of the United Kingdom of Great Britain and Northern Ireland," that's you, "of the knowledge of the comparative jurisprudence and ethnology of the chief European countries, including the United Kingdom, and the circumstances of the growth of such jurisprudence, to the intent that the common people of the United Kingdom may realise the privileges which in law and custom they enjoy in comparison with other European peoples, and realising and appreciating such privileges may recognise the responsibilities and obligations attaching to them." But for the last bit, that could have been UKIP. The first series of Hamlyn Lectures was delivered in 1949 under the title Freedom Under the Law by a newly appointed Lord Justice named Denning. They've continued in an unbroken line ever since, and I think today they can lay claim to being the premier series of law lectures in the common law world. Miss Hamlyn, I hope, would have been proud. She would certainly have been happy, as the trust is, that this year's series is being delivered by Professor Paul Craig, and that Paul has chosen Oxford as the venue for the first of his three papers. As Timothy Endicott has said, the succeeding ones will be delivered in Belfast at Queen's University and then in London at Gray's Inn, of which Paul Craig is a bencher. Paul Craig is a public lawyer of both national and international distinction. He is an Oxford graduate, a former Vinerian scholar, winner of both the Gibbs and the Henricus Prizes, a Fellow of the British Academy, an Honorary Queen's Counsel, and since 1998 the holder of the Chair of English Law in this university. He is also, among many other things, the alternate United Kingdom representative on the Venice Commission, which gives constitutional advice to the 46 other member states of the Council of Europe. His textbook on administrative law is one of the most cited and most highly regarded books in the field, along, I hasten to say, with Timothy Endicott's. The theme of Paul's series of lectures this year is administrative law, nationally, within the EU, and globally. Tonight's paper on the foundations of UK administrative law is subtitled Common Law Method, Values and Contestation, and it thus picks up and broadens the theme of last year's lecture series given by Lord Justice Laws on the common law. With great pleasure, I ask Paul Craig to speak.
Thank you very much indeed, Stephen. Thank you for the kind introduction, and also Timothy. It is a great honour to be giving the 66th Hamlyn Lectures. I ought to just put what I'm going to say in context in order that it can be understood. The book which will emerge from this set of lectures will be entitled UK, EU and Global Administrative Law, Foundations and Challenges. So just a small topic. The breadth of the subsequent book I lay entirely at the blame of the trustees, who intimated to me at the outset that they and indeed Cambridge University Press might not be averse to the fact that the subsequent book was a little longer than 3 lectures would normally be. So I then took them at their word, or perhaps a little more than their word, and applied the principle which some ascribe mistakenly to Blackstone, and it really goes back to Hale, which translated from the Latin roughly says, give them an inch and they'll take 400 pages. And that's roughly what it's going to be, because the final product will be a book of somewhere between 150 and 170,000 words. And because I'm a very simple person, as I've told generations of students, so it's a very simple structure. And the simple structure has 2 chapters on each legal system, foundations and challenges of UK and EU. And what I'm going to be doing in the 3 lectures that I'm giving actually as part of the Hamlyn series is that I'm going to be talking about the foundations chapters, the foundations of UK administrative law, of EU administrative law, and of global administrative law. And today's lecture is the one about UK administrative law. Now, in this chapter, I advance a model of common law constitutionalism that is more moderate than that presented by some other writers, but which I believe and argue best captures the historical provenance of the subject, is consonant with constitutional principle and coheres with current legal practice. Now, the chapter begins with a discussion, a theory of how the common law evolves and the interrelationship of value and doctrine in that evolution. That evolution is analysed from 3 related perspectives: a conceptual perspective, a judicial perspective, and a constitutional stroke administrative perspective. That is followed by analysis of the relationship between theory, value, and fact within public law discourse. The focus then shifts to the relationship between common law and legislative intent when considering the foundations of judicial review. Now, I cannot possibly cover all that material in this lecture. The chapter currently sits, stands, or kneels at about 30,000 words, and however fast I talk, I certainly can't cover 30,000 words. So choices must perforce be made, and I have made a choice. And what I'm going to deal with today is the relationship between the common law and legislative intent, which, if you want some rough figures, covers approximately 25% of the chapter, and it will be the focus of this lecture. The debate burned fiercely at the turn of the new millennium. It may or may not surprise you to hear that I concede nothing. The effluxion of time has not led to change in my view, but it has lent perspective on the central issues in this discourse. The core contentious issue remains unaltered. It is the claim that the precepts of judicial review must be based on legislative intent, since if this were not so, such review would constitute a strong challenge to the sovereignty of Parliament. The lecture will be divided into 4 parts. The first section is designed to clear the ground by rebutting 2 prominent objections to the relevance of the debate. Firstly, that it has no doctrinal significance, and secondly, that it has no normative significance. The remaining sections address arguments that have been put as to why legislative intent must be regarded as central. I contend that the only way in which we can make progress is to disaggregate those arguments. And there are three different kinds of arguments which will be considered in sections 2, 3 and 4. An analytical argument, an empirical argument, and a normative argument. So no one can claim that any argument has been left behind. So let me begin with part 1. And part 1 is what I regard as clearing the ground, addressing these two related arguments. First of all, the debate makes no doctrinal significance. Secondly, it makes no normative significance, or difference rather. The argument or the jibe that the debate between proponents of the common law model of review and those who insist that the legislative intent is vital in order to avoid a strong challenge to parliamentary sovereignty, that jibe has been put, the jibe that it makes no doctrinal or has no doctrinal significance, has been put by a number of writers, Trevor Allen being amongst them. The conclusion is right, the reason is wrong, and the error is important. The critique assumes explicitly or implicitly that the reasons why there are scant, if any, such doctrinal consequences is because the resulting doctrine is somehow an admixture of the common law model combined with legislative intent. That might indeed be true if the model in issue were that of specific legislative intent. The shift from specific to general legislative intent is, however, much more profound than the mere adjectival change would indicate. The specific intent model was predicated on the assumption that Parliament had such an intent as to the meaning and application of review in a particular instance, and in that sense could validly be said to be part author of the resulting doctrine. The general intent model is in reality entirely different and is in fact a modified common law doctrine rather than a modified ultra vires doctrine. On the general intent model, Parliament is taken to intend that its legislation conforms to the basic principles of fairness and justice which operate in a constitutional democracy. However, because Parliament itself cannot realistically work out the precise ramifications of that general idea, it leaves or delegates power to the courts, which then fashion the more particular application of that idea in accordance with the rule of law. Now, the real reason why the modified ultra vires doctrine does not lead to different consequences from the common law model is quite simply that the former has no content whatsoever other than that provided by the latter. The legislative intent, the general legislative intent, is merely nothing more than a key to unlocking the door to allow the courts to decide on the ambit of judicial review in accord with the rule of law. It has no specific content, this being determined by the courts in accord with whatever they choose to include within the principles of review pursuant to the rule of law ideal. The reality is, therefore, that the modified ultra vires doctrine functions merely as a renvoi back to the common law, which is why in the 400-year history of judicial review there is no doctrine that owes its origin to general legislative intent or anything like it. It is no answer in this respect to contend that the specific statute might contain indications as to the nature or incidence of review. It might, and if it does, then proponents of the common law model have accepted, always accepted, that that will be taken into account. The modified ultra vires model has in any event nothing further to add in that respect, since by definition the general legislative intent will be insufficiently specific to discern the contours of judicial review in a particular statute. What I have said above in terms of the fact that the modified ultra vires doctrine brings nothing new to the table and therefore leads to no different doctrinal consequence, that is equally true in relation to the other adjectival shift advanced in the literature, which is the move from specific legislative intent to constructive legislative intent, which you find in the work of Trevor Allen. Thus, Trevor Allen acknowledges that it will be for the court to decide on the appropriate restrictions to place on administrative discretion, and then in doing so, they draw on a range of constitutional values. However, the values that inform the constructive legislative intent are synonymous with the rule of law. Once again, constructive legislative intent performs no function in relation to the identification of those values. It simply expresses the conclusion about the choices which the courts have already made. It serves no independent function and has no independent content. Let me move on then to the second tier of this first limb, the argument that it makes no normative difference. It is common, once again, to see the argument that the debate concerning the foundations of review doesn't really matter in normative terms. It is regarded as conceptualism, using that term in a derogatory manner, which conceals, so it is argued, the real normative issues, or those that are fundamental for any regime of public law. That argument is evident in the work of different writers. Tom Poole is one, Trevor Allen is another. So we have the arch opponent of common law constitutionalism and the arch proponent, both making the same argument in that respect. Now, the argument that there is no doctrinal difference is, as I've mentioned already, right for the wrong reason. The argument that there is no normative difference, or that the normative issue is unimportant, is quite simply wrong. The requirement of legislative intent, whether specific, general, or constructive, means, and this is unarguable, that it is not constitutionally legitimate for courts to apply common law doctrine to a statute in the absence of such intent. Thus, while those who subscribe to the modified ultra vires model, such as Mark Elliott, while they now acknowledge more clearly than before that the existence, in inverted commas, of the principles of judicial review is derived from normative precepts such as the rule of law, it is integral to their thesis, it is the very core of their thesis, that application, in inverted commas, of the principles must be grounded in some legislative intent, since it is thought that this would otherwise entail a strong challenge to sovereignty. Legislative intent, thus conceived, is the condition precedent for judicial review, in the sense of an operative set of principles used by courts to decide real cases. In the absence of such intent, the principles may exist, in inverted commas, in the abstract, but are inapplicable to real statutes in the real world, which provides the foundation for circa 90% of public law authority. It follows on this view that the courts cannot legitimately apply such principles in the absence of such intent. The courts do not, therefore, have autonomous legal power. That's pretty important if it's right. It's wrong, but it's pretty important. The stakes are even higher because I'm going to demonstrate in part 2 that if it is correct, if the argument is correct, then this limits the application of any common law precept to a statute, irrespective of whether it concerns public law, contract, tort, restitution, or indeed criminal law. That I will demonstrate in part 2. Now, you may think that this proposition, the proposition that the courts don't have autonomous legal power, you may think it's uncontentious and orthodox, you may think it's contestable and heterodox. The importance of the proposition, one way or the other, cannot, however, be denied. It is fundamental and foundational to our legal order. It is not conceptual formalism, and it's not a side issue. It is central and underpins much else. It speaks to the respective powers of courts and legislature in a constitutional democracy. It encapsulates different views about the relationship between the rule of law and Parliament. To argue to the contrary is untenable, and to feign indifference is to fudge the normative issue. Consider in this respect Tom Poole's own summation of common law constitutionalism. You cannot adhere to the constituent elements of that theory while at the same time expressing or purporting to express indifference as to the normative proposition adumbrated above. You cannot at one and the same time maintain, in accord with his depiction of common law constitutionalism, and this is his own list, his own depiction goes as follows: a political community is ordered according to a set of fundamental values, the primary repository of which is the common law as articulated by the courts. That ordinary politics do not necessarily connect with fundamental values, and that public law consists of a set of higher order principles and rights which can be used to set aside political decisions. You cannot maintain that as your vision of common law constitutionalism, whether you think it's right or wrong. You cannot maintain that and at the same time maintain that it is illegitimate for the courts to apply such principles to statute without legislative intent. This is neither normatively nor conceptually coherent. The respective parts of that formulation can only exist by radically reinterpreting one or undermining the other. If the former part is taken seriously, there's no normative foundation for the latter. If the latter part is taken seriously, it denudes the former of all substance. Consider in this respect also Trevor Allen's alleged indifference as to whether public law doctrine is grounded on the common law or legislative intent, coupled with his repeated iteration that the relationship should best be conceived in terms of sharing between common law and legislative intent. The reality is that as the modern scholar that best exemplifies Tom Poole's articulation of common law constitutionalism, he is not and cannot be indifferent to the normative premise that underpins the legislative intent model for the reasons set out above. Trevor Allen does not in reality accept that the normative force of the rule of law is dependent on any linkage with legislative intent. Nor, moreover, can the normative issue be resolved through invocation of the verb to share, as if that had some magic property. To the contrary, the verb to share in Trevor Allen's work takes on a very specific connotation, which comes close to denuding that word of all meaning. Thus he regards the common law as the source of the foundational values that constitute the rule of law. He contends that Parliament is not able, even expressly and unequivocally, to depart from a particular precept that constitutes the rule of law in any particular instance, and he believes that courts can and should invalidate primary legislation via constitutional review for non-compliance with the rule of law thus broadly defined. Now, you may well agree with that view or not, as the case may be, but do not pretend that the answer one way or another is advanced by recourse to the concept of sharing, and do not pretend that the answer is premised on indifference as to the normative issue examined here. Let me move on then. So that's the end of part one. Let me move on to part two. So I believe that the issue is of normative importance for the reasons that I've just put on the table. So let me move on then to consider the different arguments which have been advanced as to why legislative intent is necessary to prevent a strong challenge to parliamentary sovereignty. The first argument is what I call the analytical argument. Now, analytical arguments are great. I like them. They have a certain cutting edge to them. They have a power and a force. The desired goal is reached through a logical form of argumentation, the force of which cannot be denied. The result may or may not be desirable, depending on the content of the argument said to be proven. It's the analytic logic that imbues the resulting conclusion with its strength. There is, however, a flip side to this coin, a double price that has to be paid. If you rest your thesis on an analytical argument, then you had better make really, really sure it works. You also must ensure, less obviously, but equally importantly, that it does not lead you in directions that you do not wish to go. Why is that so? Because an analytical argument has its own integrity, which must be followed through to its logical conclusion, even where this creates problems that the author would rather ignore or deny. Academic life being what it is, and academics being human some of the time, the normal response is a bit of both. If you're the academic and you have not, if you see the problem and you're the academic, there's a temptation to ignore it, hoping that others will not notice. If you've not seen the problem and it's pointed out, then the natural temptation is to deny or distinguish the situations to preserve the force of the argument. That strategy, both limbs are inherently precarious. Ignoring and hoping that no one will notice is simply giving hostage to fortune, because sooner or later someone will. Denying and distinguishing is equally problematic, because it can only be judged a success if it fits with the integrity and logic of the analytical claim, all of which is as it should be. Those who seek to live by the analytic sword must recognize that its power is indifferent to authorial parentage. The analytic argument was at the forefront of the claim that legislative intent was crucial for the legitimacy of judicial review. It was indeed the hair that set the whole debate about the foundations of judicial review running. It was initially articulated by Christopher Forsyth back in 1996, who contended that in the absence of such intent, judicial review would constitute a strong challenge to parliamentary sovereignty. He maintained, in what has become famous as part of the debate, that what an all-powerful parliament did not prohibit, it must be taken to authorise either expressly or impliedly. From this, it was said to follow that all elements of judicial review must be cloaked with legislative intent, since if this were not so, the assumption would be that Parliament did not intend the constraints on statutory power to exist, with the consequence that the judicial imposition of such limits would amount to a strong challenge to parliamentary sovereignty. That's the analytic claim. And actually, even now, when you look at the literature, that's regarded as one of the foundational planks on which the whole tableau of the need for an intent rests. The analytical argument is, however, problematic on both counts adumbrated above. It doesn't work, and it leads in directions that its supporters would rather not go. I will consider those points in turn. Now, the difficulties with the argument, the analytic argument, were noted in 1997 by Sir John Laws, who pointed out that there may be circumstances where we do not have any intent about an issue one way or another, what he termed the undistributed middle. That argument was never developed by Sir John and was treated dismissively by adherents of the legislative intent model. that was unwise, for Sir John Laws was right, and his argument has very far-reaching implications. Let me try and draw out what those implications are. The reason resides in the nature of the inquiry, the question which we put. Consider the following very simple example. We wish to inquire of the legislator's intent in relation to error of law. Review for error of law. We could pose any of the following questions. Administrators should be subject to some control for error of law. That's one formulation. Secondly, court should be able to substitute judgment on all errors of law. Thirdly, court should be able to substitute judgment on jurisdictional or collateral errors of law. Fourthly, court should substitute judgment on some issues and exercise rationality review on others. Fifthly, they should show, other things being equal, greater deference to legal determinations made by tribunals pursuant to the 2007 legislation, but not to others. Sixthly, the intensity of review should be based on functional considerations. And lastly, that there should be no distinction between review for law and fact at all. Now, just reflect on that list of 7, and it's just a very simple list. The legislature would probably only have any meaningful, definite intent in relation to the first of those queries, or the queries put in the first way, viz. That the administration should be subject to some control for error of law. In relation to all the other options, the legislature would likely have no intent one way or the other, and the choice between them is the real doctrinal issue. The legislature would not understand the issues or the implications of the choices. I should make clear that entails no disrespect to Parliament at all. The reality is that many generalist lawyers would not have firm views on those questions, and the reality is also that specialists disagree. Now, whether it is even possible to have an intent on an issue that you do not understand is a matter which I leave as an action point for the jurisprudence group to debate over a few pints in the Lamb and Flag or whatever their other venue of choice is. It's the sort of thing that you can imagine people talking about over a couple of pints, and then somebody else sitting nearby sort of overhears them and thinks this is exactly the sort of thing that people should talk about in Oxford, and do talk about in Oxford, and then writes this funny letter to the Times or something. In any event, action point to the jurisprudence group. But what I've just said reveals, in effect, a deeper problem with the analytic argument. If its force is restricted to very abstract determinations about which Parliament might have a definite intent, viz., for example, that there should be some control over errors of law, with a more detailed doctrinal specification delegated to the courts, then, of course, in those circumstances, there is very unlikely ever to be a clash with parliamentary sovereignty, since Parliament will likely express an affirmative answer to the question posed at that level of abstraction. But this affirmation of Parliament's sovereignty is purely formal and formalistic, since the courts would then make the real decisions through the other 6 choices among the options listed above. If, by way of contrast, the focus of the analytical argument is tested against the real choices that shape review for error of law, or indeed any other doctrinal issue, it can no longer be contended that that is necessary to prevent a strong challenge to parliamentary sovereignty, since that argument is premised on the assumption that Parliament has a definite intent on the particular doctrinal issue one way or another. If it does not, then the courts could choose between any of the available options listed above without fear of infringing sovereignty. So, in my view, the analytic argument doesn't work. If it is felt that judicial power must nonetheless be predicated on some approval or delegation from Parliament, then that must rest on a normative claim, and I will unpack the normative claim in part 4. But before doing so, I want to tease out the second part of this section. The analytic argument, which is where this argument will go if it's right. I've said it's wrong, but let's imagine for a moment that it's correct. Let's presume it's correct and see where it leads us. The logic dictates that legislative intent must equally be regarded as the foundation for all bodies of law, including contract, tort, trust, property, restitution, and the like, where the common law principles are read into legislation. The reason is simple and readily apparent. Legislation is commonly read subject to those common law principles unless there is something to indicate to the contrary. Thus, tortious liability rules will be deemed applicable to all statutory contexts, irrespective of whether the statute concerns public or private bodies or an admixture of the two, unless there is some statutory rationale to modify or deny their application. The same is true for contractual, proprietary and restitutionary rules. If the analytic argument is correct, then we must equally cloak the application of such common law principles to statutes with legislative intent in all areas of the law. Statutes are enacted against the backdrop of common law doctrine and presume its existence, such that the way in which they are applied will be shaped by the common law rules. Those rules constrain or condition the way in which the statutory power is exercised, unless the statute specifies to the contrary. If it is felt that some positive legislative intent is necessary to cloak judicially created precepts of public law with legitimacy when applied to a statute, then the same must also be true in relation to judicially created principles of contract, tort, trust, property and restitution. Now, what might be the response of the proponents of the legislative intent model? Well, there's two possible responses. They might, of course, accept the force of the preceding argument and contend that legislative intent must be regarded as a condition precedent in all areas of the law whenever common law principles are read into legislation. This might, I don't know, it might be accepted with equanimity by those wedded to the analytic claim. It's unlikely, however, to be a view which is shared by scholars in private law, criminal law and international law who do not and have never conceived of their subject in that manner. Such a view is, moreover, based, as will be seen in part 4, on mistaken normative assumptions about the nature of sovereignty and the respective role of common law and statute as sources of law within our legal system. So what's the alternative strategy? If you don't affirm, then they might seek to deny and distinguish. This is the more likely strategy, but its plausibility depends on advancing an argument that preserves the application of the analytic claim in the public law context while successfully denying its applicability to other legal areas. This is no small task, and I have yet to see an argument that comes anywhere close to doing so successfully. So, for example, there are hints in the literature to the effect that private law is different because, for example, private parties require no authorization before making a contract, whereas public bodies have to point to some such authorization to enable them to act. There may well be truth in this, but it's wholly irrelevant to the present argument. It is indeed looking down the wrong end of the telescope. The issue is not whether private parties can make contracts without any prior authorization. They can. The issue is whether the common law rules devised to regulate those contracts require legitimation through legislative intent when they are read into legislation. And that's the issue, irrespective of whether it relates to public or private parties. The former proposition does not touch the latter, nor does it furnish any reason for distinguishing the application of the analytical argument to all areas of the law. It may help to ground and finalise this section by taking a simple example which tests the point I've made above. Consider a particular statute which is made. Many statutes are applicable, of course, to public bodies and private individuals. Many statutes deal with issues that cross legal subject matter boundaries. The distinguishing exercise whereby the analytical argument is held applicable to public law principles read into the statutes, but not to common law principles from other legal areas, does not withstand examination. It entails the firm affirmation that legislative intent must be found when public law principles are read into the statute in order to safeguard parliamentary sovereignty, coupled with the equally firm affirmation that that is unnecessary when the relevant principle is derived from contract, tort, trust or restitution. That would in turn generate nice, and I mean nice in inverted commas, nice doctrinal contestation as to whether a particular precept was properly to be regarded as coming within public law, thereby requiring the legislative intent trigger, or whether it should properly be viewed as an aspect of private law, in which case it could be waived safely through the system without it. It also generates nice, in inverted commas once again, inquiries as to what should happen when the same common law principle, for example, fault or restitutionary liability, is applied in a statutory context to both public bodies and private parties. There would assuredly be room for an academic symposium, I'm sure funded by the British Academy, with papers arguing rival positions as to whether legislative intent was required when such liability was applied in a statutory context to the private party as well as the public body. The reality is that the distinguishing exercise is untenable, leading to distinctions that would make the debates that beset medieval scholasticism look positively principled. Let me move on to part 3, which is the empirical dimension. So, I don't believe, as you've just seen, that the analytical argument works. So let me move on to the empirical dimension. Empirical arguments have an intuitive appeal based on their factual foundation. An argument derives succour and support from its attachment to practical reality. It's therefore unsurprising that this dimension has assumed greater prominence, more especially with the adjectival shift from specific to general legislative intent. The former, specific legislative intent, was subject to the critique that it was empirically unrealistic to assume that Parliament had any specific legislative intent as to the application of the precepts of review in a particular statute. The latter, general legislative intent, was said to be justified because Parliament could realistically be regarded as having a general intent that administration should be subject to general precepts of substantive and procedural legality, the details of which would then be worked out by the courts acting pursuant to authority delegated or left to the courts by Parliament. Now, empirical arguments often come with an edge. They are proffered with a latent, or indeed not so latent, challenge, which at its most basic takes the form of deny that if you can. This is a jibe uttered in many contexts, from youth to old age. It may indeed be an integral part of human nature. Its present application in the context of intellectual controversy does not alter the essential character of the argument or the intuitive appeal of making it. It really resonates with basic instincts that we all have. It goes back to the kind of playground where some kid comes up to another kid and says, "Go on, what he said, deny that if you can." Yet all good things come with attendant dangers. There are three problems, serious problems with the empirical argument. First, there are some who seem to maintain that the empirical claim resolves the debate between the common law and the modified ultra vires model in favour of the latter. There are some statements by Sir Philip Sales and Geoffrey Goldworthy which give the impression that all you have to do is to sustain the factual foundation for the empirical claim, which then proves the triumph of the latter model over the former. That is clearly untenable because is does not imply ought. The fact that such intent might, for the sake of argument, exist furnishes no normative reason for concluding that it is necessary for the legitimacy of judicial review. Second, the argument elides approval and creation. I have no doubt whatsoever that empirically grounded general legislative intent could doubtless be posited for all manner of things, including an end to child poverty, international conflict, and economic recession. I have no doubt either that it could equally be posited for liberty, equality, and human happiness. That does not mean that anything done by Parliament necessarily had a causative impact on ending any of the former, nor does it necessarily mean that its general approval, Parliament's general approval, was a necessary condition for the existence of any of the latter. In the same vein, empirical proof of general legislative intent provides no evidence that the legislature had any role in the creation of the principles of judicial review. Third critique. If, nonetheless, it is felt that mere approval in the preceding sense suffices for general legislative intent to be regarded as the foundation for judicial review, even if it has played no part in doctrinal creation, then you face the real problem, which is that the same must equally be true for all areas of the law. There is no more or less reason to say that the legislature believes, for example, in basic principles of justice in contract as mediated through concepts such as autonomy, consent, responsibility and the like, the details of which will be worked out by the common law courts through a delegation of power by the legislature when it is unable to make detailed provision for such matters itself. There is equally no more or less reason to say that the legislature exhibits a general intent that tortious liability should be fair and reflect some appropriate balance between corrective and distributive justice, between fault and non-fault liability, the details being once again worked out by the common law courts pursuant to legislative authorization of power. Precisely the same exercise could be applied to all areas of private law and indeed criminal law. If, therefore, the empirical argument as to general legislative intent suffices for the conclusion that such intent is foundational for public law, then the same must be true for all areas of the law where statute exists. Let me now move on to part 4, the normative dimension. Normative argumentation is central to public law as it is to other legal disciplines. It is often assumed by adherents to the ultra vires model that if we get down to the normative dimension, then the legislative intent model wins in normative terms because it coheres with the constitutional orthodoxy of parliamentary sovereignty. Indeed, the very sanctity of parliamentary sovereignty, protected through the cloak of legislative intent, is presumed to give this model its normative superiority. There is, however, a paradox here, because the normative claim is untested. It is asseverated, but, as I have said on a previous occasion, asseveration is not argumentation. It is assumed to be self-evidently true, and it is portrayed as axiomatic when it is in fact neither. The argument has never been unpacked, and the reality is that constitutional orthodoxy over 400 years does not conform to that postulated by those who support the ultra vires model. This misreading of constitutional orthodoxy is the consequence of mistaken assumptions about the meaning of parliamentary sovereignty, combined with equally mistaken assumptions about the relationship between courts and legislature. There are in reality three different models of sovereignty in play, and the distinction between them is crucial to the normative dimension. They embody very different assumptions about the relationship between courts and legislature in a constitutional democracy. The live issue is which model best reflects and coheres with UK constitutional tradition, and I will argue that it is the first. The first of the three models is indeed the classic model of continuing parliamentary sovereignty. It embodies the idea of legislative omnipotence in the sense of ability to change. That is reflected in its central tenets. There are, on the one hand, no substantive limits on Parliament's power, such that it can, in theory, legislate on any subject matter, and there are no procedural limits, such that it can do so by simple majority, uninhibited by any manner and form limits laid down by an earlier Parliament. Now, I'm not suggesting that there shouldn't be limits. I'm merely saying that's the classic model. The centrality of capacity to change is also reflected in the traditional precept that Parliament is not bound by any other organ and can therefore overrule earlier Parliaments and judicial decisions. The consequence of that view is that judicially created controls of public law or in private law can apply perfectly legitimately unless Parliament has indicated otherwise in pursuance of its continuing sovereignty. The second model I have termed, and I think just as a descriptive term, but I think it's descriptively accurate, the second model I call the statutory monopoly model. This demands, in addition, that an integral aspect of sovereignty is that any legal norm that impacts on legislation can only be legitimate if it has the imprimatur of the legislature through some prior showing of legislative intent. The model of sovereignty therefore demands that Parliament must give prior approval to any limit or term read into legislation as a condition of constitutional legitimacy, with the consequence that judicial power is contingent on finding such consent. It does not suffice on that model that Parliament can change, reject or modify any conditions imposed by courts. The third model is more far-reaching yet again, and I term this the parliamentary monopoly model. The idea of general legislative intent was devised because it was recognised that the specific intent model was implausible, hence its replacement with general legislative intent, connoting the idea that Parliament intends some general precepts of substantive and procedural legality to apply and leaves or delegates to the courts the task of fleshing out the doctrinal content that Parliament is enabled to do. But that reasoning could indeed have broad implications for relations between courts and Parliament, irrespective of whether there is legislation in the area or not, since it is at its most fundamental grounded on the idea that all authority must be traced back to and receive the imprimatur of Parliament in order to secure constitutional legitimacy. On this view, common law judicial rulings, even in the absence of legislation, would have to be rationalised on the ground that Parliament intends general precepts of justice relevant to contract, tort, property, crime and public law, and then leaves or delegates to the courts the task of defining their doctrinal content, the legitimacy of the judicial rulings being dependent on that connection with legislative will. Now, the distinction between the first model and the other two was recognised once again, actually, by John Laws in a one-liner, which no one quite saw the force of at the time, and I didn't, though I did remember to go back to it. But he rejected the claim that judicial review without legislative intent entailed a strong challenge to sovereignty, noting that the argument was, quote, vitiated by an implicit mistake, the mistake of assuming that because Parliament can authorise anything, all authorities and prohibitions must come from Parliament. Sir John Laws, again, he didn't develop that thought, but Sir John Laws rightly regarded that as a non sequitur. Trevor Allen, in his work, contends that John Laws missed the point, since all common law rules are vulnerable to legislative abrogation, with the consequence that a public body's jurisdiction is always a function of the scope of its statutory grant, however broad or narrow Parliament has chosen to make it. To the contrary, it is Trevor Allen that has missed the point. John Laws's insight captures the distinction between the models of sovereignty I have set out above, although he did not express it in those terms, and those models of sovereignty are simply elided by Trevor Allen. Christopher Forsyth's analytical argument is predicated on the assumption that sovereignty means the statutory monopoly model as defined above. John Laws's insight was to recognise that being all-powerful in the sense of the continuing sovereignty model did not logically entail the conclusion that all constraints on legislation must necessarily be authorised by Parliament ex ante in order to be constitutionally legitimate. The fact that the common law rules remain vulnerable to legislative abrogation is indubitably true, and is indeed central to the classic model of continuing sovereignty, which has at its core Parliament's ability to amend, repeal and change. The analytic claim that legislative intent is required to prevent judicial review from being constitutionally illegitimate is, however, premised on the assumption that the statutory monopoly model is true. Now, I am not denying that a legal and political system might choose that model. I'm not saying that the model is somehow a priori impossible. Not at all. I'm not saying the third model is either. A legal system might choose that model, but that should not mask the fact that it is different from the classic model of continuing sovereignty. So, in the final 5 minutes in this lecture, what I will argue is that the reality is that the classic model, the first one, best coheres with our constitutional tradition as judged by 4 criteria: constitutional scholarship, the status of judicial decisions as sources of law, judicial practice, and how we conceptualise conflicts between courts and Parliament. Let me begin with constitutional scholarship. It is noteworthy in this respect that prior to the debates about the foundations of judicial review, which occurred at the end of the last millennium, there was no academic indication that such doctrine entailed a strong challenge to sovereignty in the absence of legislative intent. That is not just an interesting historical fact, though it is an interesting historical fact, nor is it fortuitous. is reflective of the fact that sovereignty, as enumerated by the classic writers such as Blackstone, Dicey and Wade, and indeed Cook, embodied the continuing sovereignty model. Their formulations are framed in terms of the sovereignty as parliamentary capacity to change prevailing rules or create new rules afresh. There is no hint whatsoever in those classic formulations that sovereignty also entailed the statutory or parliamentary monopoly models where it is inherent that you require prior authorization in the sense adumbrated above. Now, of course, I accept that it might be argued that this was regarded somehow as implicit by such writers and others who wrote on sovereignty in analogous terms. But come on, there is nothing whatsoever to indicate that they did think that, unless, of course, you wish to wheel out the idea of an implied general constructive or some other intent that they meant this when they didn't say it. So that's the first reason why I think that model number one is the preferable one in terms of our constitutional tradition. Second, consider next the implications of the choice of sovereignty model for how we conceive of relations between courts and parliament. The statutory and parliamentary monopoly models have a profound impact on relations between courts and parliament in the following sense. It is axiomatic in our constitutional system that judicial rulings are sources of law, and this is supported, albeit in different ways, by writers from positivist and non-positivist legal theory. It is chapter and verse in first-year courses. Legislation is a source of law, so too are common law decisions. The latter are sources of law and constitutionally legitimate, subject to the fact that they can be overruled by the former, that being an integral aspect of continuing sovereignty. That standard reading of our constitutional system must, however, be significantly revised if we subscribe to the statutory monopoly model, let alone the parliamentary monopoly model, with its strictures of prior legislative authorization. Why? Because it means that common law rulings cannot be regarded per se as constitutionally legitimate when applied in the context of legislation unless they're cloaked with the imprimatur of the legislature signalled through specific or general intent. They are not regarded as a valid source of law unless such content can be located, because it is said to entail a strong challenge to sovereignty as embodied in that model. That stricture is applicable to all common law doctrine read into all legislation, not just that concerning review. It is inconceivable that constitutional scholars from previous generations would have regarded that as something marginal or interstitial, let alone that it would have been left to implication. Nor would those who made public law and the common law, nor would Coke, Holt, Mansfield, Kenyon, Abbott, the great judges from the 17th and 18th century, have accepted that statutory monopoly model at all, since it ran counter to accepted orthodoxy concerning the relationship between courts and parliaments in our constitutional system. The third limb of the argument, judicial practice. The classic orthodoxy of judicial practice is exemplified by the legality principle as developed by the courts in cases such as Witham and Sims. The common law recognised certain fundamental rights, and it was for the courts to determine their meaning and ambit. The application of such rights could be qualified by Parliament in the sense that their continuing sovereignty would enable them to change, alter or repeal what had been done at common law. The courts policed the conditions on which this could take effect, demanding express words or necessary implication to limit such rights. and the circumstances in which the latter would be satisfied were construed narrowly. The orthodox position is exemplified once again by Lord Reid giving judgment on behalf of the Supreme Court in the recent BBC case, where he stated, quote, that since the principle of open justice is a constitutional principle to be found in the common law, it follows that it is for the courts to determine its ambit and its requirements subject to any statutory provision, with the consequence that, quote, the courts therefore have an inherent jurisdiction to determine how the principle should be applied. That is, I believe, a classic formulation of the idea of the continuing sovereignty model and exemplifies the argument that I have been making. Thus, the relevant constitutional principle was to be found in the common law. The common law courts determined its ambit pursuant to their inherent jurisdiction, subject to any statutory provision. There are many other judicial statements to like effect, such as those given by Lord Coke and Lord Bingham in Daly, who regarded the common law itself as the foundation for the right of confidential information. Consider finally the way in which we conceptualise courts, conflicts between courts and Parliament, and the way in which that reinforces the argument being made here. We hope that courts and Parliament are in broad accord as to the legal rules that should pertain. We know that that does not always happen in the shorter term. It is the way in which we regard such tensions that is of interest here. These can occur when Parliament dislikes a particular judicial decision. They may be apparent in parliamentary distaste for a general body of legal doctrine, and they may be manifest when Parliament takes or threatens action that is regarded as more deeply problematic from the perspective of the legal and political order. The key issue in these circumstances is that we do not regard the judicial decisions thus rendered as illegitimate in any of these circumstances, merely because they provoke the ire or discomfort of Parliament. That does not mean that courts always get it right. They do not. That's not the issue here. The point is that even if Parliament states that it never intended the legislation to be subject to a certain constraint, we do not therefore regard the judicial decision imposing that constraint as illegitimate, as would be the implication of the statutory monopoly model if it were taken seriously. Let me then conclude. The respective roles of court and legislature remain central to the foundations of judicial review. The requirement of legislative intent means that it's not constitutionally legitimate for courts to apply common law doctrine to a statute in the absence of such intent. The courts do not, in that sense, have autonomous legal power. This limits the application of any common law precept to a statute, irrespective of whether it concerns public law, private law, or criminal law. This is not correct, nor does it capture the relationship between courts and Parliament that is our constitutional heritage. For those who take the contrary view, the magic wand of general legislative intent will have to be waved to sanction each area of legal doctrine when common law precepts are read into legislation. Or perhaps we might just take a lesson from Chicago efficiency. We could simply posit Parliament issuing one grand or wild card to the effect that Parliament leaves or delegates to the common law courts the power to construct just rules for all forms of legal relations, combined with the correlative assumption that Parliament can be taken to intend to comply with them whenever it legislates in the relevant area. Just be mindful that if this step is taken or accepted, it should be done with eyes wide open. This is not constitutional orthodoxy as we have known it for 400 years. It does not reflect our existing conception of sovereignty. Thank you very much indeed.